Good evening, one and all. We have today with us Advocate Hariraj M.R, who is practicing at the High Court of Kerala. He is an accomplished professional who was my senior back in college and as well as in the profession. And he's an author. He is practicing in service law. Specialization is in service law. He has written a book on service law as such, especially in the context of the general civil service, civil servants as such. And he is somebody who has constantly strived to maintain rule of law. Rule of law, as you know, is a concept which is abstract, but which is all pervading. And the success of a country lies in upholding rule of law. And he is personified in relation to fighting for rule of law with respect to even forgetting about other relationships. He's always somebody who champions the cause of rule of law. And he is somebody who has been consistent with respect to his position in the courts in relation to upholding this concept. Even when the client may want some hanky-panky business, somebody who does not really go along with that kind of an activity, somebody who upholds professional ethics to the highest degree. And he was in the previous year, he was vice president of the Kerala High Court Advocates Association. So somebody who is really into the profession for around more than 2 decades. He's been there in the profession and successful in career as well. So we are lucky to have him to explain this abstract concept so that you get a better idea of what exactly is this conceptually and how it fares in practice also, because this is something that uh, theory sounds very great, but in practice it is very difficult to actually get it implemented, get the people to accept it and to uphold it in its true spirit. Over to you, sir.
Thank you. Revered, respected, beloved, everybody who is present over here. I certainly cannot see everybody. I can only see Mr. Anil R. Nair's face. It's very happy thing to listen to good words spoken about yourself, knowing fully well that it is not fully correct. However, in fact, I should confess that I accepted this invite to talk on rule of law under a thorough misconception. I thought that I had a fairly good familiarity with the subject. I use it on a daily basis in the court. I have read a lot of judgments on rule of law. I have tasted textbooks on the concept as suggested by the great Bacon, though I have not chewed and digested any as he would have liked me to do. But then, preparing for the presentation, I realized that my acquaintance with this concept is best described as knowledge about the sea of a person who is selling peanuts on the beach. I am very certain that I know how it sounds and look like. I may also know where to find it, but I still may not be very sure of being able to explain it fully to anybody. How do we explain the sea? Is it the water? Is it the waves? Is it the depth? Is it the breeze? Is it all of these together and many more? What really constitutes the sea? How can sea be explained? One must wonder, and I am similarly bewildered, where to start, where to proceed, and where to end when called upon to talk to you about rule of law. But then I think I'm not alone. I'm in fairly good company. When I read through, I found that Lord Thomas Bingham, who was the Lord Chief Justice of England and Wales, has similar idea. In his book, Rule of Law, he says he chose the subject of rule of law because the expression is constantly on the people's lips. I was not sure what it meant. And I'm not sure that those who use the expression knew what they meant either, or meant the same thing. So he thinks that is a good reason to study something. And I also feel I must be in really good company. There are a lot many people who think, lot many academic brilliant minds who think the concept of rule of law is at best an elusive notion. Some commentators like Jeremy Walden would opine that rule of law is nothing but a different way of saying hooray to our side. Whatever we support is rule of law, whatever we don't support is not rule of law. That's how we usually approach the subject. That is how the usage of rule of law is asserted to be the basis of both the thesis and the antithesis in most concepts. But then rule of law is a concept that has come to stay, and it has so much of popularity in our political and legal thought. It has actually formed part of economic thought also. As early as in 1977, I was coming across an article on that. As all of you probably know, this concept of rule of law has been part of the basic structure of the Constitution as early as from Keshavananda Bharati onwards. Rule of law finds place in international documents like the Universal Declaration of Human Rights, leaving such a very important concept without at least an effort for being very clear about what it actually means is a risk which should not be taken, according to me. So it is worth at least an effort to sit back and contemplate actually what we mean by rule of law. And then the question is, do we have rule of law? There are a lot of people who would say that rule of law actually doesn't exist. It is still something which is only on the paper. There are a lot of people who say that we are working towards rule of law. We have not quite reached there, but we are still in progressing towards it. Then there will certainly be a class of people who would say, yes, all is well, and we are having rule of law. Something, again, where there is a lot of divergence of opinion. And in practice, we probably feel that in one case, rule of law is actually implemented. In another case, rule of law is not implemented. As Jeremy Walden said, hooray to our side. That's what probably drives it also. So I would say rule of law is to jurisprudence what God is to theology. Number one, we are not sure what it is. Number two, we are not sure whether it exists. Number three, there are at least some who think that it can and may not exist, and we are working towards it. And the closest parallel I can draw possibly is the concept of God. And with that in mind, let us discuss about rule of law. I would rather like to have it as a very interactive session because, as I told you, I have fairly no big clue about what exactly rule of law is. So I would also be open to learning. If anybody can enlighten us about what they feel is rule of law, that's also open. Should we call for some responses from the students here?
Well, for
What do you feel is rule of law? I'm not saying question what is rule of law is never going to be answered. I'm very sure. So at least what do you feel is rule of law is my question.
can we identify certain principles to be essential of rule of law?
So, from my understanding, rule of law essentially means that the law is supreme and that no human being is above the law, and that we must respect each other's rights. And even if a person's fundamental rights are being infringed, it must happen by a fair process, and it must not be arbitrarily infringed. I think those are like the principal components of rule of law.
Wonderful. I think fairly that's a very clear idea about what exactly is rule of law, because if one is to ask what is the concept of rule of law, of course, is the words are coined by none less than Daisy in his book on constitutional law. But the concept is far, far older. And sometimes the Western thinkers take it all the way to Plato or Aristotle. The thinkers on this side of the globe will try to recognize and find some reference to that from Mahabharata or the Rig Veda or maybe Arthashastra, etc. And they're all correct. because the concept of rule of law probably is as old as human civilization. From the moment we have started to come together and live together, there is rule of law. Even inside a family, there is rule of law, isn't it? There are unwritten laws, there are unwritten rights, there are unwritten privileges, and then nobody is above that. Correct? Unless that exists, a family doesn't hold together. It's very difficult. If anything that holds people together essentially have to have some kind of what do you say, a reflection, a small light of rule of law has to be there wherever people are together. And what I couldn't get the name, Ms. Prasad.
Padmavati.
What she said is very correct too. And I think essentially the question is, we said it is the supremacy of law. The essential question probably would be, what exactly is the purpose for which law is used? Is it a rule? Is it a rule or governance or authority by the law, or the authority under the law? Is the question. The what do you say? Is it that you consider law as a tool of the authority, or is the authority the tool of law? I hope I think I cannot put it any better. Is law the tool of the authority, or is authority the tool of law?
Does it mean that law is supreme, or is it authority that is supreme?
Precisely. That is right. When Padmavati was putting it, she said, nobody is above law, law is supreme. So law must be using the authority to get something implemented. We have the law, then we have the court, which the law uses the court to get something done. We have the executive, but executive is but the tool of the law, which the law uses to deliver something. Correct? So we are not governed by an individual or a collection of individuals, a majority of individuals. The whole electorate doesn't form the power center. The power vests, in fact, in law, or the concept of law, the concept or principles of legality. And when that is fully implemented, we have full-fledged rule of law. Otherwise, we don't have it. We probably work towards it. So the supremacy of law, as understood by Daisy, contains, as you all know, there are usually, we say there are three principles on which the supremacy of law, equality before law, and predominance of legal spirit. Of course, this has been discussed in most of our smaller textbooks in a very truncated manner. What Daisy thought was basically something which existed in his time in England, and he was comparing the English system with the continental system, and he was actually therefore criticizing the continental system of having joint administrative or something like that, which enables the government to have certain special privileges, the government to have special courts and separate tribunals for determining governmental actions, legality, etc. He was not in favor of that. Therefore, he said those aspects, according to him, violated the supremacy of law. It violated the equality before law, and it also violated, according to him, the principle of predominance of legal spirit. That is where discretion would have no place in deciding things. Rather, it should all be decided based on law. So that was what Daisy was targeting at. But then gone are the days of Daisy. He has been criticized widely by the academics as also by practical lawyers, because it doesn't work that way most of the time. Even in England nowadays, we find that there are special tribunals, special courts, and special way of dealing with certain special aspects. because as human civilization develop, it probably requires a new approach to everything. And rule of law is not a static concept. It can never remain the same. What is rule of law today, or what we understand as part and parcel and inviolable for the purpose of rule of law today, may probably tomorrow become something which is very antithetic to rule of law also. And it has been so earlier days when whatever was considered to be rule of law may not probably be considered as rule of law today. Because as you know, we must have heard about Magna Carta. Magna Carta said all free men will have the right to be tried by a fair court. Correct? And you should understand that at that point of time, all were not free men. All were not free men. So what at that point of time they considered as rule of law did not include everybody. Today, including everybody is very necessary for what we call as rule of law. If you exclude anyone, we consider that as antithetic to rule of law. And that is how the civilization has developed. So certainly rule of law cannot remain static. It will be a very dynamic concept. I therefore thought that it would be better to rely on a more recent exposition of rule of law by Lord Thomas Bingham. His book on rule of law is a wonderful read. He has exposed the question of rule of law in the modern context, and he enumerates 8 different ingredients instead of 3, and each of his ingredients is, according to me, fairly well drafted, at least as far as our times are concerned. We don't know what a century later somebody would speak about that, but as on today, it feels that that would be a good place to start our consideration and thought about rule of law. His first ingredient, according to him, is that law must be accessible. And please note this, law should be accessible and so far as possible, intelligible, clear, and predictable. Very, very practical, according to me. That words, so far as possible, before intelligible, is, according to me, very, very practical. It is not always possible to be intelligible with respect to law. He gives wonderful examples, which I will not quote for our purpose. It is not necessary, number one. Number two, it is not possible to cover all that here. Primarily, it demands that law must be known. It should be accessible to the people. According to me, it will contain a lot of things. It certainly requires publication of law, which has been accepted as early as in 1951 by our Supreme Court, Harla versus Rajasthan, which says that unpublished law is no law. And as recent as in 2016 Supreme Court, Union of India versus Param Industries, where a notification was actually notified, or rather printed on the Gazette on 3/8/2001. And it was brought out for sale only on 6/8/2001, because 4/8/2001 and 5/8/2001 were holidays. And the Supreme Court said that the notification will not take effect till 6/8/2001 because it was not available to the public. So at certain areas, we are very strict relating to the ingredients of rule of law. This is one such area. Publication of law is very, very strong. Now, is it just publication of law? I wonder, because it is not just publication of law. According to me, it should be also in the language of the people it proposes to govern. Most of the time, our legislations, our judgments, etc., are all in English. It is not actually accessible to people. Most of the people, of course, we are all here on internet, conversing each other, seeing each other on internet. Most of my research work has gone on the internet using the computers, but it's a hard reality that fairly a good percentage of Indians do not have access even to electricity. So leave alone network and computers. So this particular digital divide is there. This particular economic and educational divide is there. That is something to be bridged if we aspire to have any kind of rule of law, because the very first ingredient, according to Lord Bingham, is access to law. And I would also, on lighter vein, add we have a lot of judge-made law, and the prolixity of most of the judgments makes it even more inaccessible to lawyers like us, because we don't have the time to read 800 pages of judgment and make head or tail out of it. Most of the judgments that come out these days, if you have ever ventured into the adventure of actually reading it, you will find is a formidable fortress of as far as thought is concerned. So that is something which has to be certainly addressed, leave alone the abysmal legislative drafting that has left us high and dry. Then the second ingredient he speaks about is that the question of a legal right and liability should ordinarily be resolved by application of law and not by discretion. So he gives a kind of margin. It should be ordinarily by the law and not by discretion. Rather, it means to say that there can be discretion. There certainly can be individual discretion which determines rights of people, liabilities of people, but that particular discretion cannot be totally unguided. It cannot be a nude power that is vested. And that principle has been established fairly well in India. A lot of decisions are there. You will find one of the most recent decisions where this particular aspect was considered was Roger Matthew versus South Indian Bank, where the question of qualification of members of the tribunals were under question. A new act basically left it all to the government to determine the qualification. In fact, the Supreme Court said that nude, unbridled and unguided power is violative of Article 14, Equality Clause and Rule of Law. But they said there is no such conferment of nude power in that particular case, because the guidelines have to be gathered from various statutes, and mind you, including the judicial precedents. I don't know how the Supreme Court fell to the trap of believing that our executive lawmakers will read these past judgments, understand them, and apply it. The consequence of Roger Matthew was that the statute which was set aside has come back practically verbatim in its reproduction as a new statute, and it is also challenged and it's pending before the Honorable Supreme Court. And at the same time, we find that the Supreme Court has been again reluctant to say that an unguided power as far as ex gratia compensations from the Chief Minister's fund to victims of crimes is bad in law. They again said that it's ex gratia payment. There are other possibilities. In fact, we find, according to me, with great respect, our Supreme Court slightly deviating from the principle that unbridled discretion should not be there. Our apex court has become more and more accommodative, according to me, to administrative discretion, which earlier has been certainly thought as very, very antithetic to rule of law. That decision you will find in Sanyam Lotha 2011-13 SCC, if you want to have a look at it. The third principle, if I'm crossing the time, please inform me. The laws of the land should apply equally to all, save to the extent that objective difference justify differentiation. The well-settled principle of classification, there should be an objective differentiation and it should be justified. And unless that is there, there is no proper classification. And classification and discrimination are two different things. And to the extent of classification, it comes within rule of law. The extent of discrimination, it falls out of rule of law. And all the questions of reservations, all the questions of classifications made on the basis of qualifications, circumstances, geographical, economical, all this will be covered under this principle. You will find that the principle of classification, the principle of intelligible differentia and the rational nexus to the object sought to be achieved, justifying the classification, that whether that test any further survives is a question which probably has to be discussed separately. One would say that from E.P. Royappa, it is the new principle that applies. That is the question of arbitrariness. But then that is not totally devoid of criticism. In some cases, they still rely on the principles of classification. So it is still open. Then the fourth ingredient is that the ministers and the public officers at all levels must exercise the powers conferred on them in good faith, fairly, and for the purpose for which the power are conferred, without exceeding the limits of such powers and not unreasonably. So you will find there are power conferred. Conferment of power on individuals is, at least in the concept of rule of law, the method by which the law proposes to achieve certain ends. So the law has conferred powers on you, and those powers have to be exercised by law fairly and for the purpose for which it has been conferred on you. I think everything, including division of powers, has to be discussed in that particular area. We will find judgments which read more like bare acts these days. According to me, falls short of rule of law. Even the government policy and government legislation is taken over by courts. According to me, it falls short of acknowledging rule of law as in existence. Then, of course, on the administrative side, we find a lot of examples where power has been exercised for reasons other than it is vested. One of the most recent thing which we had been dealing with from our office is the appointment to the personal staff of the ministers. Some of you must have read it in the newspapers. We find that there is total ipse dixit, nothing more than the ipse dixit of the minister, which determines who becomes the personal staff. And appointments are made, payments are made from the state largesse, from the state exchequer, and pension is also given, and that has been challenged and it is now pending. You will find two decisions on this particular aspect. One is Renu versus District and Sessions State 2014 SEC decision, and State of Punjab versus Brijeshwar Singh Chahal. In fact, Brijeshwar Singh Chahal is something which I came across preparing for this presentation. That goes to the extent of saying that even the government leaders and the council appearing for the government has to be appointed through a selection. That actually runs counter, or rather impliedly overrules one of the decisions of the Kerala High Court, which said otherwise, which said that spoil system can apply there. So the Supreme Court, again, when it comes to the executive concept, it is very, very strict as far as applying this principle of exercise of power for the reasons it is vested. But when it comes to judicial realm, it has its own relaxations. Fifth one is law must afford adequate protection of fundamental human rights. I will be a little fast over here because we all know a law which doesn't recognize the fundamental human rights will be no law. Article 13, as far as India is concerned. And we all know even Hitler was justified by law for what he did. So it is not just the letter of law, but the principle of law which forms the basis of rule of law. Means must be provided for resolving without prohibitive cost or inordinate delay bona fide civil disputes which parties themselves are unable to resolve. So in fact, Lord Benham now includes into it the possibility of mediation and conciliation to take the disputes outside the realm of courts. But it would still say that when it is not possible for the parties to find them via media and hit a mediation, it must be available to them without prohibitive cost and without undue delay. And both of these concepts, without prohibitive cost and without undue delay, as far as India is concerned, is still a very, very far cry. I can give you n number of examples where delay has actually jeopardized rights of people. One of the most recent experience from my side is a matter where a person had given a place on rent, and he was not getting the rent. The tenant was not paying him the rent. He went to the court. The law says that if the tenant does not pay the rent, he will not have the right to contest the case. So he filed a petition saying that let the tenant pay the rent which is due. The court directed the payment of rent. Payment was not made. The court evicted him. The court directed eviction. That was as early as in 2018. From 2018 onwards, my client has been running pillar to post for getting this eviction order implemented. And it took him time till 2021 to get the actual eviction done. And when the actual eviction was done, the tenant left the place without removing the movables. You get the picture? The tenant evicted, but the movables are still there. And my client cannot take over the movables because it doesn't belong to him. And now the court is under another procedure whereby the court will sell these movables and hold that amount in trust for the tenant, mind you. And unless and until my party succeed in another suit which he is yet to file, he will not get the arrears even to the extent of the movables. This is the system under which we are working. Very, very strange when it, of course, very lucrative for a lawyer, but I would say very unfortunate and strange when it comes to from the angle of the client. I can say it only in this crowd. If I speak it out in public, it probably would be cutting the branch on which I am sitting. But it's still something which I want you to have in mind. These kind of systems which we need a very thorough revamping. It is under this principle of rule of law, we have the principles of legal aid, the principle for speedy justice, the principles for speedy trial, the principle for access to justice. All these principles have been recognized as fundamental rights, but still we have a very, very, very long way to go to reach the actual goal. And the seventh principle is, seventh ingredient is that the adjudicative procedure must be fair. The procedure must be fair. I have a case of a war veteran who actually saw action in the war against Pakistan, not once but twice. He, after the second war, resigned to take care of his mother. And now he is at the sunset shores of his life, as one would say. And he is also suffering from cancer. So he calls back to the government and demands that in relaxation of the rules, a person who resigns doesn't have pension. In relaxation of the rules, please give me pension. No response comes from the mighty government, which swears on the people guarding our borders at least thrice a day. No response comes. He goes to the High Court. The High Court says, please give him a proper hearing and decide his case. He is just claiming a relaxation, which he cannot claim as of right. The High Court also knows that there is no possibility of a right to relaxation, but please consider this and give him a hearing also. And unfortunately for him, the COVID comes in between. The hearing happens online. The hearing happens online. He, with great effort, found out how to log in onto whatever application was suggested by the director of CRPF or something like that. And he logged in. He said, "Good morning, sir." And the only words he heard back was, no, your claim cannot be allowed. And the connection got snapped. And he was never permitted back into the room after that. This, according to the CRPF, is hearing as contemplated by the High Court. This particular method, according to me, you will find a number of examples of this anywhere, even good cases, bad cases. The procedure has to be fair. The justice should not only be done, it should ostensibly appear to have been done. Is a principle on which we work. The principles of natural justice, the principle of bias, the principle of odi altrum partem, and the principles of recent orders being given. All this will have a bearing on this principle, on this ingredient, that the adjudicative process of the state must be fair. The adjudicative process as of now is not just with the courts. The adjudicative process as of now is with both the courts as also the administrative authorities. So all these authorities, all the courts, everywhere, it should remain fair. And the boundaries which demarcated the administrative and quasi-judicial exercise of power has long withered. It no longer exists. And therefore, every procedure has to be fair and should appear to be fair. Part of the problem is normally solved when you give a very patient hearing. And impartiality, of course, with all this, we have to go to courts which conduct hearing. Less said the better, because we have had the Supreme Court hearing a case relating to the ex-Chief Justice with the Chief Justice on the bench. Then the judgment comes without the Chief Justice name on the order. Fairness is an attribute which you cannot buy with money. Impartiality is not mere independence. We have an independent judiciary, but impartial judiciary is not merely achieved by independence of judiciary. Impartiality demands independence not from the executive and the legislature. Impartiality demands independence from oneself. I'm very certain somebody hearing me over here, young students, one day would probably adorn the bench somewhere. Please keep this in mind. If you are on the bench, don't just try to be independent from the executive and the legislature. Please try to be independent of yourself. Unless you can manage it, it is better to throw in your papers and come back. Better options are available at the bar. The final ingredient, Lord Bingham says, is that the rule of law requires the compliance by the state of the obligations it has under the international as also the national law. So that aspect, Lord Bingham says, because he has been a very strong proponer of the fundamental human rights, and we don't find declarations of human rights too many in Britain. Probably that is one good reason why he insists that the Universal Declaration of Human Rights, the European Declaration, etc., should find acceptance and compliance by the states. And he also would say that when the state demands that its subjects must comply with law, the law which applies to the state should apply with equal vigor to the states. Otherwise, there is no rule of law, because it also touches on the question of equality. So these are what Lord Bingham says, which according to me probably is a more detailed exposition of what rule of law today is, or rather it probably helps us to consider a lot of aspects which actually we find around us, probably test the events, incidents and consequences based on what we have actually seen. And I think I would conclude there, if that is all right. I would be open to any questions, and I'm not very sure about the answers, but I'll certainly be open to questions.
No, in the context of the lawmaking exercise itself, it's a political thing. Because when you started off with respect to that Magna Carta, you mentioned that of free men. Now we talk about us being a participative democracy, where which is actually the one that creates the law in the first place. We're supposed to. But we have a constitution which was not really created by or in the process of being a participative democracy. So how do you really consider? I said that because the persons who were part of the electoral college who created the constitution were not really representatives of the people. They just happened to be people who could get that nomination, and it did not really reflect all the entire what do you call the 600 plus native kingdoms that joined into the Indian Federation at a later point in time. So we have a system where the mother law itself is based on something that is not really politically correct as per the concept of rule of law as we were looking into it. But on the other side, there is this argument that the subsequent elections have actually validated the creation of the constitution. But then the original constitution has been drastically changed with the concept of basic doctrine, the doctrine of basic structure being brought in subsequently, with certain elements, especially right to property, being taken away. Now, how do you look into all these things with respect to the concept of rule of law as it exists in India, as compared to what the Thomas Bingham is suggesting? Because ultimately, everything is dependent upon what the law is, and the law is still in the hands of not the people, but certain elements or certain sections of the people.
No, I would put it this way, because the concept of rule of law does not depend so much so on the written constitution we have. According to me, it depends more on the principles that has been evolved over a period of time. See, the Constitution of India, definitely, it is not 100% participatory democratic process that led to the Constitution of the Constituent Assembly. Probably, yes, true. But with all that, it did reflect, it did have a fairly good cross section of the Indian polity at that point of time, minus, of course, the people who left to the other side of the border. But with with the discussions, it's one of the most well discussed and well debated piece of legislation that we have ever had. Constitution, as we see today, then has transformed a lot by virtue of the amendments, by virtue of judicial pronouncements. And most of the time, you will find it is not merely the ipse dixit of a party in power, or even the principles as it was exposed by some judge sitting somewhere in ivory tower. It does reflect to a great extent the will of the people, which the will of the people is not always reflected on electoral ballot alone. It is a vibe. It is a concept that develops by virtue of interaction with people. It is a concept that we develop from within our society, because the society's opinion does change. We have seen that our opinion relating to lot many things have undergone substantial changes over the years. The Indian polity as a whole, if you take, you will find that the approach, attitude, etc., has changed and keeps on changing. I don't say that it will not change tomorrow. And we have a substantially important, a substantially good constitution to that extent, and we have the right to amend. But rule of law depends not on what is written over there, but what lies underneath. That is why the principle of amendment has been restricted, according to me, by the basic structure concept. The basic structure is what forms the edifice on which the rule of law can exist, or rather, that is from where the rule of law would breathe its life. It is not just the declarations. In fact, Daisy would say, on the question of predominance of legal spirit, these are the words I have written down from Daisy himself. General principles of constitution is with us the result of judicial decisions determining the right of private persons in particular cases before the courts. Where is under many foreign constitutions the security given to the rights of individual results and appears to result from general principles of a written constitution. He says that is very bad. Of course, I would still say Daisy is not fully to be accepted in our present day realm, but he says, probably in view of the fact that they had a partial monarchy over there, the rule of law or the protection of the fundamental rights would flow from precedent to precedent and not from a written declaration of constitution. That is what Daisy thought. But according to me, again, it is not just the written constitution that forms the edifice of rule of law. It is basically the concepts that form the basics. And make no mistake of it, when the Constituent Assembly met and drafted our constitution, they really knew the pulse of the Indian polity, where the Indian polity needs a correction and where the Indian polity needs a change. And therefore, they have written down lot many things which probably would never have been done even with majority view. Even with majority view, I would say that with the majority view, we may not have thought about undoing untouchability. Imagine, with majority view, we would not have thought about writing the equality clause into our constitution. With majority view, we probably may not have never been able to say that everyone will have a fundamental right to life and liberty. There would have certainly been a good majority at that point of time in 1947 who thought that there is a section of people who are not so equal. There is a concept of us and them. And that us in 1947 was not the us today. So, according to me, the Constitution of India, probably not fully democratic, but it certainly is one of the best and just documents that we could have definitely obtained. That's my view on that.
Yeah, just following up on the question earlier, how do you reflect or how do you look at the fact that the Supreme Court is male dominated with very less representation for women? And it is the same court that is sitting in judgment with respect to women's rights also. So when you talk about rule of law, and this law is what the people at the Supreme Court at the helm actually lays down or says it is. How is this gender bias or gender a lack of gender parity? How is it going to affect this concept as such?
I don't know, at least as a lawyer who has been on the side of canvassing for more wider rights of people, I have always found, with great respect, female judges more accommodative on the questions of right, a little more than what the males are, most of the time, at least. So, I, for one, would certainly prefer a more higher representation of females on the bench. There is absolutely nothing wrong. The question is, we are, but still on the question of numbers. See, I was told, I don't remember in which, was it in Netherlands? Was some foreign country where a prime minister is a female. She was asked, how do you feel to be a female prime minister? She said, I'm the prime minister. I'm not a female prime minister. I'm the prime minister. So when you are a Supreme Court judge, you are not a female Supreme Court judge. You are a Supreme Court judge. And you are not a male Supreme Court judge either. You are a Supreme Court judge. So unless we stop seeing this distinction, probably we will continue to have a probably higher number of males than females, because at some point of time we fail to not to see this difference. We have to see the merit, we have to see the capacity, we have to see the strength of the individual, which certainly would be much higher for females, according to me, than males when it comes to judgment. At least we all know who makes the decisions at home.
Yeah, but I was asking the question in context of the collegium electing. It's a self-perpetuating, self-electing collegium that makes that choice of who sits on the
Okay, I understand that the question is more on the question of the method we select judges. That is probably a subject matter of a full wider discussion in another aspect, which according to me is not 100% in accordance with rule of law. Again, it is not something that has been contemplated by the Constitution. It is not something that has been contemplated under anything but the judgment of the Supreme Court itself. But of course, that is what the system is now. And it seems that the government is also to a great extent trying to accommodate that kind of arrangement without taking a very stern stand against it. Why not? I, for one, would feel that it is necessary to have a different way of looking at that aspect. But it is not merely the collegium that prevents the elevation of more female judges. Probably what the Chief Justice mentioned would also be one of the reason we are having people who do have good quality and metal but refuses to be on the bench. That is there from the male side also for other reasons. It may not be that may not be referring to the family problems. They would stoutly say, I make more money than I would ever make as a judge, so why should I go? Probably that is a reason also with the females, but they probably come up with this answer of family, etc. But there are more number of female judges than we used to have, and I'm very certain in years to come that will definitely increase. That should increase, and we will one day say it is not a male dominated or a female dominated bench. That aspect, that question would probably wither away in time. But of course, it takes time. We had very little senior advocates, uh, so to say, from among females. We had very little advocates among females to start with. And even if we had a fairly large number of females coming into the profession, we have seen that the dropouts of profession from the female side has been much higher. I think both of us, we both must have had practically equal number of boys and girls in our class.
In
But
fact, the number of women were more.
yes, and finally the dropouts are also higher. So it is also it's a very comprehensive, very composite social issue that probably will take time and time will cure it. But we have to contribute to it by some stern steps. Probably that should come from the female side rather than anywhere else.
No, when we started off, when you were discussing the fact that the concept of rule of law, you started off saying that there is this vagueness with respect to what exactly is rule of law. Some will say if it is agreeable, then you will say it is rule of law, and if it is not agreeable to you, then you say it's not rule of law. So, what is the position of under the concept of rule of law vis-a-vis resisting unjust laws?
The right to resist, is that what is being referred to? The where will we fix that particular right? Every fundamental right is to be protected if rule of law is to be recognized to exist. Every fundamental right, and that fundamental right includes the right to equality, the right to life, the right to freedoms, the right to uh, right against all kind of discrimination, everything, all the fundamental human rights, I would say, not just the fundamental rights under the part 3 of the Constitution, but all the fundamental human rights necessarily have to be protected. And right to dissent, the right to resist, the right to say that a law is unjust and therefore I will not comply with it, is in fact part of rule of law. And unless the law does accept that, it is not going to be in full tune with the concept of rule of law. The right to resist, but would also call upon the citizen to resist in a manner which is legal, I would say, because it is not possible for me to say that I am not happy with the provisions of 302 IPC and therefore I go around killing people. No, that doesn't happen. If I'm unhappy about it, go to the court, get it challenged, get it corrected, or bring up a political movement which will probably address the issue. And those kind of resistances, legal resistances, legally acceptable resistances within the four corners of the limitations on the fundamental rights that can justly be put, certainly has to be protected. That kind of resistances is acceptable and is definitely part of the portion or ingredient which says that the law must recognize the fundamental rights of humans.
Yeah, so my point is this: when we talk about this concept of rule of law, are we talking about a rule of natural law or rule of positive law?
Positive law, which is totally inconsistent with natural law, may not find acceptance. According to me, that should directly run in conflict with Article 13, at least even in the positive law side. Because what is fundamental right other than a restatement of natural law? Part 3 of the Constitution, according to me, must be understood as at least a restatement of a portion of the natural law. respecting another person's life, respecting another person's equality, respecting another person's right to speak, walk, talk, etc., is to be understood as part and parcel of this natural law, which has to exist, natural human right that has to exist in every human being. And that particular aspect, if the positive law, the written law, is not accepting, it is not in tune with that. According to me, the positive law will not have its validity. It has
So our 19(1)(f), which is essential in almost every respect with respect to all the natural rights, right to property, is taken once it is taken away from the position of being a fundamental right as such.
There the problem is we are trying to think that 19(1)(f) is part of natural law, which did not find favor, at least with the thought process of the Supreme Court earlier. 19(1)(f), the right to property, right to hold property, and right to compensation for property that is removed from you, in its nature as a basic human right, I don't think probably exist. It still is a legal right.
It's recognized under the Universal Declaration of Human Rights. 1948 Declaration recognizes specifically right to property.
Right to property, yes. I
So
say
it's internationally something that is acknowledged as part of rule of law.
I fully agree.
Rule of natural law.
I fully agree. But the problem is, as far as the natural law is concerned, a person, the society's collective will for certain aspects may have precedence over the individual's right to property. The collective will of the society at the same time may not be it may not be possible using that to silence totally the view of an individual person. That, according to me, are two different scales. I mean, it stands at two different levels in the scales. And right to property may be internationally accepted. As of now, we in India do not accept it as a fundamental human right or fundamental right, so to say. True, maybe under the demands that can later be raised, saying that it is part of natural human right under the Universal Declaration, etc. Probably sometime later, the Supreme Court may accept it also as something very inviolable. But I feel that that is a right which has to yield to the general will, the right to property.
Okay, so let me see whether there is any question from our students.
Sir, what happens to the concept of rule of law when it comes to a state of emergency? Aren't we essentially giving the power to the president or the government at the time to infringe upon rights there? What happens to rule of law?
That's an excellent question, because you will find that most of our fundamental rights are truncated, suspended, and kept in cold storage when it comes to an emergency. And we have had taste of that once in our country, and probably we are not very far from another also. Anyway, according to me, such a declaration, even in the wake of a national emergency, real or perceived, may not stand the test of rule of law. And even, I would put it this way, even when that's why I said the rule of law does not breathe its existence from the written rights in Part 3 of the Constitution. In fact, the fundamental rights you find in Part 3 of the Constitution, which will stand suspended in case of an emergency, stands on rule of law. Please understand it this way. It is not as if rule of law is sitting on Article 14. It is Article 14 sitting on rule of law. So even if Article 14 is removed, the rule of law will still exist. The rule of law will exist even if we don't have the Indian Constitution. The rule of law will exist even if every fundamental right under the Indian Constitution is suspended. Why? Even if we don't have any constitution at all, rule of law will still exist, and the rule of law would demand that everybody should still be treated equally. The rule of law would demand that every authority would exercise its power fairly, and the rule of law would demand that we should have recourse to a judicial body which will protect our fundamental rights. But of course, at that point of time, when it comes to emergency, our courts have not shown the mettle of standing up to it. We have had occasions when rule of law has been violated, and mind you, we will still have it again. And when we do have it, the only assurance is the power of the people to stand up to it and fight for rule of law. And if you want to do it, we should ensure that rule of law as a concept, as a principle, as a religion, as a concept of God should be ingrained in your mind, in the mind of the society around you very strongly. Otherwise, we would still probably suffer another round of inhuman treatment without rule of law as we had in the earlier round of emergency.
So, in extension of that question, sir, fine, in an emergency situation, this can be true, but what happens in situations like that of now, like the pandemic, for instance, where legislations like Epidemic Diseases Act or DMA is invoked? That again gives space for the authority to take up a lot of discretionary powers. The authority, there are various vague terms that so forth. Is the law using the authority to implement itself, or is the authority using the law as a tool to implement order and rule in the society? Because you made the distinction in the beginning, right, sir? The law using the authority and the authority using the law. So where exactly does such special laws lie?
Matthew, my of course, a certain portion after your word vague has been very vague to me. It didn't come to me fully, but I understand your question. I understand your question is that when the situation of pandemic etc. is there is a lot of discretionary power that is vested on the people, on the authorities, and how do we address it in the realm of rule of law? Did I get your question correct?
Yes, sir. I'm sorry, sir. Internet is a bit laggy. Yes, sir.
It doesn't matter. So if that is a question, see, rule of law is not antithetic to discretionary power. At least it is not now. Daisy thought it was, but it is no longer so. It is a case where discretionary power can coexist with rule of law. Because in fact, why do you need rule of law if there is no discretionary power according to me? If there is no discretionary power, rule of law probably slightly loses its relevance to a great extent, because rule of law is the guarantee against an abuse of a discretionary power. Discretion certainly is vested to a great extent, to a very high extent with the authorities. With the authorities having the discretionary power, how they should exercise the discretionary power is determined by rule of law. So rule of law would demand that every discretionary power is exercised, one, fairly, two, for the reason for which it is vested. So these two principles come from rule of law, then that exists even during the pandemic. So if the police inspector is entrusted with the power to punish a person for the purpose of not wearing the mask, it is necessary that the police officer should first tell him, you have committed the offense of not wearing the mask, ask him for an explanation. The explanation should be considered. The explanation should be considered and a decision should be arrived at in consideration with all the relevant factors, including his defense, and a decision should be taken. And then only the penalty can be imposed. It is not permissible for the police officer to first pull out his lathi and beat up the individual. That is where rule of law is violated. The discretion as such doesn't violate rule of law. Discretion being utilized in this manner, according to me, violates. And that is why I said the even though the statute or the rule or the government order which confers this power is very silent about the guideline under which this particular power is to be exercised, that power has to be exercised tempered with fairness, tempered with the principle that it should be exercised for the reason for which it is vested. Of course, I don't certainly see the rationale behind people saying that if I'm traveling inside my car with the AC on, I should have my mask on my face. It is basically, according to me, violates the very fundamental. It is not the reason for which that particular power is vested on the police officer. That power is vested on the police officer to ensure that there is no spread of the disease. And how am I spreading the disease when I am alone in the car? Is a question to be asked. But certainly that does happen around us. I certainly see that to that extent, rule of law is more mocked upon by our police, because police hardly understands. They don't come to this good kind of seminars and try to understand what rule of law is. Probably they should also be asked to come and understand how they have to exercise the discretion. But that education hardly is given to them. That problem is there. But in an optimum situation, discretion as such will not violate rule of law.
Sir, I have a follow-up.
I had a doubt.
Yes.
No, after you, Rubaya.
Mamati, do you want to go ahead?
After you.
All right. So you have talked about how separation of powers is a facet of rule of law. But for the past few days, we've had courts across the country release orders that are beyond their purview. For example, Allahabad High Court ordering lockdown. So it's judicial overreach and sets a very bad precedent regarding the powers of the courts, but a right move considering the circumstances. So how would you reconcile these orders in the context of rule of law?
Rabaiya. Okay. See, the right thing done by the wrong person is not something that is in accordance with rule of law. That's why I said, number one, there should be a conferment of power on you to do this thing. Second, there should be, then you should exercise that power for the reason for which it is vested in a fair manner. What is the power vested on a court? It is not a policy making body. It is at best a policy reviewing body. Correct? So it is not open for the court to take such policy decisions. The separation of power, according to me, to that extent at least, is certainly part of rule of law, because it is also bordering on the question of ultra vires. But then the courts have practically taken upon themselves lot of power which do not actually belong to them. And they have been exercising it. Article 226 and Article 32, as the case may be, has been used. And even worse, Article 142, they can do whatever they want in the name of doing full justice. All those power, most of the time, has been overreaching, but at least at some point of time, it has been very popular. And don't make a mistake of it. Merely because it is popular, it doesn't become right. A popular decision from a court of law, merely because it is popular, it doesn't become legally right. So at least as students of law, we should be able to understand it in its legal sense and look at it in the legal way. Merely because it is popular, it doesn't appeal to us. So certainly, why do we want to come all the way up to the COVID-19 situation? The overreaches on the judicial side has been there from day one. N number of examples can be certainly pointed out in that respect. We have seen they interfering in practically everything and anything. At one point of time, I heard that they were considering whether a special consideration should be given to the lawyers for getting vaccination. Practically, they took upon themselves, I don't know how the judges got special consideration for vaccination. Why not the hoteliers? Why not the transporters? They are all exposed in the same manner. That is basically when you become the law unto yourself. That is not rule of law. That is something which is against rule of law. That's why I said we definitely have the concept of rule of law. We know that it exists, or we doubt that it exists, but it is still there, and it is something like God. A lot of people have their own interpretations about that. I may call that this thing is God for me and the other thing may be God for you.
Thank you, sir.
So I have a question. So I think in the beginning you said that the rule of law is not a fixed concept and that it changes based on how the society also progresses. For example, what might be a crime 2 decades ago will not be a crime today. So on that note, I also want to ask you about the amount of discretion that the judiciary exercises in following the rule of law, because I feel like the amount of discretion that a normal person like you or me might have in following the rule of law is not the same amount of discretion that a judge has, especially in deciding the constitutionality of certain cases and deviating from old norms. So, on that note, how does rule of law kind of ensure that the judicial discretion is not unfettered and it is not way too much?
Okay, only of course, as I said, discretion as such is not against rule of law. Again, discretion has to be exercised fairly for the reason for which it is vested. Judiciary is vested with a lot of discretion. A judge is vested with discretion to decide on the question. But what is his discretion? Just please consider it this way. You have a list before you. You have evidence on both sides. And then finally, based on the evidence, you come to a conclusion that X or Y exist. And based on that factual finding, you apply an existing law and give a verdict. This is the discretion. Of course, there is a small area of discretion. You will be able to say, okay, this particular evidence is not admissible. This particular evidence is admissible, or the meaning of this evidence is this. But all those are tempered with guidelines. All those are tempered, has to be tempered with fairness, and the decision-making process has to be transparent and fair. And it is not as if there is a lot of judicial discretion which is totally unbridled or unguided. It's not as if it is written down in statute that the judge should do these things. But those judicial discretion, whatever judicial discretion we have, is in fact guided, and it has to be exercised fairly and reasonably. And when you do that, the question of what is your power, what is your brief, what is your area under which you can actually take a decision is certainly there. When an action, when an administrative action is brought to you, you can decide whether the administrative action is legal or illegal. When an administrative inaction is pointed out to you, it is possible for the court to decide that the inaction is bad. And once you find that inaction is bad, what would you do? You would ask the administration to do it. It's not for you to do it yourself. That is where the line breaks. That is where you are overstepping the fence. And that's a brief of the... See, it is not for the... I'll put it a very popular decision. And in fact, one of the most popular decision of that time was the judgment which said that there will be banning of smoking. Is it for the court to do? Is it not for the court to say that, see, smoking in public causes huge health concern. It violates the fundamental right of people. So government, you please come forward and make some provision by which this is prevented. It's true that you cannot direct a legislation, I fairly see that, but you can certainly ask the government to do something about it, either by legislation or otherwise. Then it is the discretion of the government as to how it is addressed. The violation of fundamental right is pointed out, demand the government to protect it, rather than you stepping in and becoming the government yourself and saying that from tomorrow onwards nobody should smoke on the street. Under what provision will the poor policeman take register a case is the difficulty. And that is not the way the court should work. The court should work keeping within the realm of judicial power. It is not for the court to make policy decisions. It's not for it to legislate. And there is no two ways about it. That's what I hope I have answered your query on that.
So I have a follow-up question to that. So, when following the rule of law, when the law in itself is inherently arbitrary, how do we go about following the rule of law? For example, to contextualize this question, let's take capital sentencing, right? So in Bachchan Singh, it was held that capital sentencing is constitutional, but then P.N. Bhagwati, Justice P.N. Bhagwati, he gave a dissenting opinion and said there is inherent arbitrariness in the capital sentencing procedure. And it's been over 30 years since that decision came out. And we see a lot of lack of uniformity in how capital sentencing is done. We don't have a capital sentencing framework. Like trial courts for some offenses, they might say death penalty must be given for this particular offense. But in some other cases, they might just stick to life imprisonment. So how does rule of law play in those contexts when we determine the constitutionality of an offense when there is no uniformity?
See, I have no doubt that an arbitrary, unreasonable law is no law. An arbitrary, unreasonable law is no law. A law which violates the fundamental human rights is no law. So, rule of law, we have to understand it in that context. It is not what is written in the Indian Penal Code. That doesn't form part of rule of law. Rule of law is a concept which would demand that the Indian Penal Code, which should be in tune with these fundamental rights. So, certainly, I am an advocate for saying that I certainly fully agree with your view that this capital punishment is not something that should be sustained in our rule books. It has to go. In fact, I would also go to the extent of saying that it reflects a very bad social psyche, that each time a heinous crime occurs, we have so much of a clamor on the Facebook or other social media demanding immediate hanging of, if you have noticed, that is the kind of social psyche we are having, and that social psyche is what creates terrorism, according to me. So unless that social psyche is addressed, it is very difficult. Anyway, it is necessary that the law should change as far as that is concerned, but it does take time. We would have to wait till another case like Bachchan Singh reaches the Supreme Court and another judge or a majority of other judges like Justice Bhagavati takes a view on that. So a lot of things have to come together on that. And definitely at that point of time, if the court feels that it is an unconstitutional and of fundamental right is violated, it would probably certainly strike down that that particular provision. The thing is, the concept of fundamental right, the concept of rule of law, the concept of fundamental human rights, what forms fundamental, etc., has always been very dynamic. It has been keeping on changing. It would continue to change, and we hope that it will continue to change in a positive direction, at least. Rather, when I say that, I would say that it would change in the way I want it to be. That's actually what I mean. But that, according to me, is the positive side. I don't know whether it is actually positive or not, but at least in the way myself and Padmavati thinks later, the law would change. Hopefully, that day will come edu sooner.
Well, it's getting late, but since you mentioned about that social psyche, and you were also earlier mentioning about the aspect of majoritarian, what do you call, decision-making powers when the constitution was being drafted. What is this? Is there any nexus between rule of law and popular will? Popular will as a reflection of that social psyche?
May not be. I may not say that it's 100% based on popular will either. It I'm not to that extent a fan of democracy, so to say, because most of the time the majority view does not appeal as common sense view. It Most of the time it is not something based on thought as much it is on emotion. So it is very undependable as far as a proper decision making process is concerned, and that is why we have at least at least in India and many other places, We don't have popular judges. We have popular legislators, and we have an executive which is answerable to that popular legislature. But we don't have popular judges, because this popular will is not something which unfortunately is something based on which you can take a fair and reasonable decision. That has never been. Just look at what happens around whenever we have a criminal case that is reported on the newspaper. We have TV discussions, practically cross-examining the witnesses on the TV. We have people who have not seen the papers, who have not seen the evidence, deciding what the judge should do. We have people who would say that the judge was wrong in such and such reason, such and such paper was not looked into, the evidence was, the investigation was lopsided in that manner. All these things are being projected on the, and this particular popular, what I spoke about, the popular psyche, the popular emotion is being harnessed in an unparalleled way as in history. If you find it has become so easy to mislead people, and it has become so easy to harness some kind of emotion and create so much of a ruckus. It is possible. So at that point of time, to depend entirely on popular view as far as decision making process is concerned is not a safe bet. So when the society has to go forward, it is also necessary that it has to be decided more based on principles rather than popular view, and principles that has been reflected. Some kind of, there's a kind of evolution of principles. It is not just that one principle at one day and next day we go for the direct opposite. That does not happen in a judicial decision making process to a great extent. There is a gradual somewhat kind of a flow or metamorphosis of decisions and opinion. We may probably end up from a caterpillar to a butterfly, or vice versa for that matter. But the process is slow and determined and logical, and that has to happen not through a political popular political process. It has to happen on a principle based process, and that cannot happen according to me based on a popular political view. That's why I said the constitution, though it is not 100% popular probably, but it still was based on principles which were considered, and it was actually pointing out a light to the future. It was 1950s. Whatever they have thought in the constitution never existed in India. That's 100%. Outside the Constituent Assembly, whatever was in existence was not what was reflected in our constitution. 100%. You are very right. But that is not what was supposed to be reflected either, because we wanted to change. We wanted to become a nation which is ready for the next century.
Okay, if there is any other question, please put it now. It's already almost 20 minutes past our original time schedule. Okay, so I'll take it that there is no more question as such. I hope all my students over here and those who joined from outside were able to get a grasp of the abstractness involved in rule of law, and how Hari was really looking at it from the point of view of principles rather than the legal, whatever is the statutory or constitutional law as such. It's something that goes beyond the what is written down, and which is an underlying philosophy based on justice probably, and reasonableness rather than passion and emotion. Like what he was saying in relation to the popular will and the social psyche. So it's something that needs to be looked into from a larger perspective as such, as compared to the narrow letter of law. So which really what do you call really encourages an outlook towards a natural law rather than positive law, or which allows for a dynamic nature to the positive law, to reflect the changes required as per the conditions of natural law prevailing in particular times. So let me thank Hariraj M.R for a very what you call detailed and fresh exposition of this concept. And I see that it has provoked questions from my students which were not there in previous sessions of this kind. So that has got them thinking. I hope they go further than just ask questions. They do a little bit more research and write articles on this concept, because every view, every fresh perspective gives us a better understanding of this concept as such. Thank you very much, Hari, for sparing the time and taking that effort to bring more light to this concept. It's Thursday evening and I have a heavy rain over here. And thank you all for being here, for patiently listening and asking relevant questions. We'll meet again with more such sessions at a later point in time. Thank you, everybody. Have a good